confirm that Mr Salmon took the oath at the start of this morning's evidence session. I can also confirm that all necessary mitigations have been taken, allowing us to meet safely under COVID restrictions in persons today, and we have just had a short sanitation break. Now, just before we had that break, Margaret Mitchell had asked a question. I'll ask Ms Mitchell to repeat it.
Right, Mr Salmond, it was about 2 text messages in the public domain which were in the official report from the 8th of December, and when I asked Mr Murrell about when he last came before the committee in January. And the text messages were sent by him the 25th of January 2020, the date yourself first appeared in court on criminal charges. And do you wish me to read them in full again? Okay. The first text says, "Totally agree, folks should be asking the police questions. Report now with the PF on charges which leave police twiddling their thumbs." So good time to be pressurising them. Would be good to know Met looking at events in London. And the second text says, TBH, and I presume that's to be honest, the more fronts he is having to firefight on, the better for all complainers, so CPS action would be a good thing. Mr Murrell's explanation for these texts was reflecting on these messages now. They seem quite out of character. To me, that suggests just how upset I was at the time. Now, given both Mr Murrell and the First Minister, when she spoke to Parliament about them, seem to accept these as quite reasonable explanations, I wondered if there was some doubt in your mind about the credibility.
Well, thanks, Mr Mitchell, and pardon, excuse me for the delay. 22nd of January last year, the preliminary hearing of the criminal case. We were presented with a memory stick by the Crown Office under disclosure. And we weren't able to use it, which was extremely unfortunate in the preliminary hearing. And the next day, I think it was, in the offices of Levy and McRae, we went through a series of messages. It was one of the most extraordinary days of my life because I'm not allowed to describe in any detail the messages, but let's say I recognise the one you've just read out. There are many other messages, and what they speak to is behaviour which I would never have countenanced from people I'd known in some cases for 30 years. In my opinion, there has been behaviour which is about not just pressurising the police, like the one you've read out, but pressurising witnesses, collusion with witnesses. We're talking about the construction of evidence because the police somehow were felt to be inadequate in finding it themselves. And the point about this is that on the 25th of August, I think it was 2018, a police investigation started. When a police investigation starts, these matters are for the police. They have the investigatory function. They don't need assistance from Inspector Murrell or Sergeant Riddick or Constable McCann or Special Constable Allison. Whether people are in the Scottish Government or the SNP, then they have no investigative function. It's a matter for the police. Not only shouldn't they be doing anything other than supporting the police in their activities, but they certainly shouldn't be seeking to pressurise. One other thing about this, in July of last year, because rumours have been current in the SNP for some time about such messages, Kenny McCaskill wrote to the Crown Office, and I have a copy of the letter which I'll give to the committee, asking if there was any evidence of pressurising the police by Mr Murrell. And he got a reply saying that there's no such evidence. Not a reply saying, and a reply that said the messages had been looked at. But there was no such evidence that no evidence that Mr Murrell pressurised the police, and the messages had been inspected. Not, oh, there are messages to that effect, but it didn't happen. just the message has been looked at and just a blank no. And then subsequently, Mr McCaskill, as you know, made the messages available to this committee and to the Crown Office. And as you say, they've now been confirmed, as I understand it, as being genuine, and I'm not surprised they've been confirmed as being genuine. Rather similar, I think, to this committee's experience in the lost the battle but not the war text message from the Permanent Secretary to Barbara Allison on the day that the judicial review was lost by the government. Similar in the sense that it was said in Barbara Allison before the committee that it wasn't sent to her. And then the message is revealed and the message is accepted as fact. Similar to what happened in Mr Murrell's message. There are a number of other messages in the public domain, and I can go through them if this committee wishes. There are many other messages which I am prohibited from sharing with this committee. When a police investigation starts, all other activity should stop. It's not for the SNP or the Scottish Government to supplant the police in their investigative function. It's for everyone to accept that's the due process of law and should be allowed to continue without impediment.
That's been very helpful in establishing just the veracity, I suppose, of the explanation and setting that in context. It raises very worrying issues, especially as Mr Murrell was on oath when he gave us that explanation. So thank you for that. That's helpful.
Thank you. I'm going to move on now to Mr Cole-Hamilton and can hear that Mr Salmon's chest is sore. So if we could try to avoid huge, long questions and responses.
I think it's the answers that should be shorter.
I didn't like to say, you know. Alex Cole-Hamilton.
Thank you, Convener, and welcome back, Mr Salmond. I hope you're feeling a bit better. Can I just say, we'd like to put a pin in your offer there, because we might like to hear those messages. Perhaps other colleagues will pick that up with you. I certainly would. I've got quite a lot of ground to cover, but you'll be glad to know that a lot of this is yes-no answers. It's about, in particular, the two meetings we're aware of. One on the 29th of March between your former Chief of Staff, Jeff Aberdeen, and the First Minister in the Parliament, and then the meeting on the 2nd of April in the First Minister's house. We understand that on learning of the investigation, you asked Mr Aberdeen to try and broker a meeting with the First Minister, and that in her evidence, she said that she agreed to meet with you on the 2nd of April. Is it your position that the First Minister was aware of the arrangement to meet with you on the 2nd of April before she met Jeff Aberdeen on the 29th of March?
No, my position is that the meeting of the 2nd of April was arranged on the 29th of March.
It was arranged then.
And I know this because Jeff Aberdeen phoned me on the 28th of March, the day before the meeting, to tell me it was going to take place. And he phoned me the day after the meeting to tell me that the meeting had been arranged for the 2nd of April, which I think was Easter Monday, in Glasgow. I mean, self-evidently, the only person who can invite you to their home is the First Minister. I heard Mr Murrell saying several times that I was regularly popping in. Can I just point out that I stay 200 miles away from Glasgow?
Yeah.
And as far as I can remember, I've been to Nicola and Peter's home 6 times in my life, maybe slightly more, but it's not a question of just popping in.
And I understand that your relationship with the First Minister had begun to deteriorate anyway. It's not like you'd just be popping in for a friendly cup of coffee.
Well, even when my relationship with the First Minister was extremely good, I didn't pop in because she stayed in Glasgow and I stayed in Aberdeenshire, and that was an arranged meeting. And that was the purpose of the meeting on the 29th of March. And I can answer anything else you like.
That's great. I'd really like to unpack just that particular arrangement around the 29th of March, because this is very important. In her evidence, the First Minister is quite vague about it. I mean, that tallies with the fact that she suggests that she forgot it. She suggests that she forgot it because she also suggests that nothing of real consequence was discussed other than the arrangements for that meeting, and that you had something serious to talk to her about, potentially around allegations that you were facing. Can I just ask about Jeff Aberdeen? So he told you that he was going to meet the First Minister the day before you got that call from him, confirming that meeting was going to happen. Did he explain where that meeting was going to take place and what time it was going to take place?
He told me the meeting was going to take place on the 29th. As you know, Mr Aberdeen had been approached by another official who brought him into the process, and the meeting was taking place with a view to briefing Nicola and arranging the meeting for the 2nd of April. As you know, the meeting of the 2nd of April, my former Chief of Staff, Mr Aberdeen, and Mr Duncan Hamilton on my council attended with me. It was a meeting arranged for that purpose.
Very good. And on the conclusion of the meeting on the 29th of March, did Mr Aberdeen give you a readout of what was discussed in detail?
No, he told me the next day that the meeting on the 2nd of April was on. He didn't have to give me, because the purpose of the meeting was to brief Nicola on what was happening and to make sure the meeting on the 2nd of April was taking place. But
it was your understanding that the First Minister already knew about the complaints and the investigation, or was Mr Aberdeen breaking that news to her at the 29th of March?
The first confirmation, I mean, anything I've said today, as I've said a number of times, I've got documentary evidence for, or evidence for, where there's no dubiety about it. So I know that Nicola Sturgeon knew about the complaints process at the meeting on the 29th of March because I was told so by Jeff Aberdeen, who told her a meeting arranged for that purpose. Whether she had any prior knowledge of it, I cannot say, but I know that she knew on the 29th of March.
Does it strike you as somebody who has described herself as being somebody as close to you for 30 years as anyone outside, within her family, practically, a strong personal ally of practically a generation, that if she's learning this huge news about your personal life, about the investigation that is happening under her own government into you, if she was to, as she suggests, just find out at that time or on the 2nd of April, do you not think that the reaction would have left a mark, that she would have remembered those occasions?
Well, I think that's a question you should direct at Nicola when you see her next week. All I can say is the meeting on the 29th of March was not impromptu, was not accidental, was not popping her head round the door. It was a meeting arranged for that purpose, and the meeting on the 2nd of April was not popping in to Nicola and Peter's home. It was a meeting arranged for that purpose.
Thank you. That's very helpful. And on the I want to turn to the meeting of the 2nd of April. And the First Minister says in her written evidence to this committee that she agreed to meet you for 2 reasons. The first was personal and the second was political. The first was she understood you to be in a state of profound distress around the news that she thought you were going to give her at the meeting. And the second one it was that she thought you were going to resign your party membership and that she would have to prepare the party for that eventuality. She had that belief. And this is why I asked you about resignation before in respect of the Edinburgh Airport meeting. Because if that's not a reaction you're given to, if that's not something you would react in a normal way to that kind of allegation, why would she believe that you were going to resign from the party for a set of allegations she hadn't even, professes to not even heard about? What do you think she believes happened there?
I don't know. My own view is that insofar as the Edinburgh Airport thing was important, it was important on the impact it may or may not have had in the Permanent Secretary. It was not, as I now know and can confirm, a matter of any consequence. And I don't think anybody was actually thinking about it by the time we got to the following April. Certainly I wasn't. As far as the resignation from the party, right, well, let's consider the circumstances. I had received on the 7th of March the indication from the Permanent Secretary that there was an investigation launched against me. I, with my counsel and advisers, was looking away for why this could be done properly, amicably, and certainly confidentially, not just in my interests, but in the interests, as was said before, of complainants and everybody else with an ounce of sense. What possible purpose could resignation from the SNP contribute to that situation? I mean, a public resignation of me from the SNP at that stage would have been regarded as astounding news, and it would be the diametric opposite of what I was trying to achieve. So I had no thought of resignation whatsoever. It never entered my mind at that stage. Why should it? It was the diametric opposite of what I was trying to achieve. I was trying to find a proper, considered response to a situation, some of which I couldn't understand because I had no idea where that policy had come from. It was, in that sense, a bolt from the blue. But certainly resignation from the SNP never entered my head.
So just to confirm, neither you nor any of your lieutenants had let the First Minister or any of her private office know there was a suggestion that that was on the table?
Well, when you're under oath in a committee, you speak for yourself. Yeah. I had not indicated to anyone at that time that I was about to resign from the Scottish National Party. And, you know, I'm here under oath telling the truth, and that's what I'll do. But yeah, I think I would have, just as I said, appealed to sort of a rational appraisal of that. A resignation from the SNP would achieve the diametric opposite of what I was looking and hoped could be achieved.
Thank you. I'd like to move to the 2nd of April, and this is critical because the First Minister's version of events is diametrically opposed to yours and other people's version of events of what happened at that meeting and the revelation of, firstly, the fact of the investigation, that was the first time that she'd learned of it, and secondly, that whether she was going to help you or not. And this is critical because it speaks to the ministerial code, a possible breach of ministerial code, which if found to have happened and she'd misled Parliament, then she would be required to resign. Can I ask you, when you attended the meeting, you met with her in private for a period. Would you please tell us a brief summary of how that discussion went?
Well, we discussed the situation. We discussed what I'd been sent, which was not comprehensive, but had some detail in it. There was no suggestion that you know, she was surprised and astounded at what the meeting was for. The meeting was for that purpose. We went through that. I was looking for the options that we had, and as we've already discussed, the one that we'd centred on as being proper and a reasonable thing to suggest, and incidentally proper for the First Minister, was a mediation policy which was absent from the policy we'd seen for no apparent reason. And for the reasons I detailed in my submission, that was something I thought Nicola could and should go ahead with. The indication she gave me is that she was willing to do that, but she wanted an appropriate time. Her difficulty wasn't in intervening. It was that she didn't want to initiate it with the Permanent Secretary as opposed to waiting till the Permanent Secretary came to her. And that was the distinction she was drawing. But she gave me every indication, as I would have expected, from somebody I'd known over that period of time, that if it was proper to assist, that she would do so. And I felt the mediation proposal was a proper thing to ask for two reasons. One, because it should have been in the policy and wasn't. And secondly, as I've explained in my submission, that over and above any other duties, a First Minister has an obligation to make sure their government is acting lawfully. Obviously, my counsel came with me for that purpose to, even at an early stage, point out the manifest difficulties with the procedure which we were undertaking. It should be said that at the meeting, Nicola didn't show a great knowledge of the procedure itself. I mean, she was quite vague about where it had come from.
Can I ask, sorry to interrupt, during that discussion, you've already said to Ms Bailey that the name of one of the complainers was intimated to you and 3 other people. Did the name of that complainer come up in that discussion?
I think it did, but it wasn't introduced into the position because it had been told to Mr Aberdeen before then.
So you think it did come up in the discussion? With the
I think
President?
it did, but it's not.
It wasn't.
It's not something I've tried to recollect, because, and the reason for not trying to recollect it is because I know the name of, as we discussed earlier, the name of the complainer was given to me, offered to me by Mr Aberdeen, who'd got it from a senior government official, let's see, about 2 weeks previously, slightly more than that. So what didn't come up as an issue because it was already known.
Yeah. Which is surprising, because yesterday in Parliament, in First Minister's questions, she said that she didn't believe that you had been passed the name of a complainer. So I do find that surprising. We'll take that up with the First Minister herself. I just have a couple more questions, Convener. So you clearly indicate from WhatsApp exchange messages on the 1st and 3rd of June in 2018 that you left the meeting on the 2nd of April with that impression that she was going to assist you. But then also in those messages, it's clear that she changed her mind. How did she communicate that to you? And what did you think was going to happen and then she withdraw in terms of an offer?
Well, I didn't have any communication with Nicola beyond the phone calls and the text WhatsApp messages that are detailed to you. So you have everything that there is to have apart from the phone calls. As you can see from the messages, it was something of a surprise to me when she said that, I've said I'm not going to intervene, and I say back to her, that's not my recollection of what your position was. That was a surprise and a disappointment, and obviously felt to me like a substantial and disappointing change in her position. Why I wasn't sure, but it certainly was a change in her position.
In her view, absolutely. And one final area, Convener, just back another aspect of the 2nd of April. While you were there, do you recall Peter Murrell arriving home?
No, I didn't. I wasn't aware of that. I was told, because I was on my way to America, and I got dropped off at Glasgow Airport. I think we were on a taxi. I think it definitely was a taxi, actually. And on the way to Glasgow Airport, we discussed that Peter had arrived, but I hadn't seen him, so I didn't know that had happened. I was told on the way to the airport.
And final question on this, Convener. So,
I should just say, there was no surprise to me that Peter wasn't there because of the nature of what we were discussing.
Because you believed it was government business.
Well, I knew it was about the complaints that had been made against me. There was no other agenda or business that I was aware of, and as I say, it's not the geography, apart from anything else, dictates I wasn't just popping in.
And if this had been a meeting to help the First Minister prepare herself and the party for either the impact of the investigations, the revelations around them, and or your resignation, as she suggests it was, would you have expected Peter Murrell to know about that, to have some involvement in that, even during the meeting?
Well, yes, but it wasn't. So it wasn't a surprise to me that he wasn't there, and so Peter's non-attendance wasn't a surprise because I knew what the meeting was about.
I'll pause there, Convener. Thank you.
Okay, Murdo Fraser.
Thank you, Convener. I wonder if I can just follow up just a couple of the points that Mr Cole-Hamilton put to you, and then perhaps ask you something else briefly. But I just want to be clear about the version of events, particularly in relation to the meeting on the 29th of March that Mr Cole-Hamilton has referred to. You've set out your position. You say in your written evidence that, and I quote, quoting from your written evidence about the First Minister's version of events. In fact, you're referring to the meeting here, 2nd of April, that the First Minister's claim is wholly false. Now, Nicola Sturgeon was somebody who you worked with very closely over a long period of time. She was your deputy when you were First Minister and succeeded you as First Minister and leader of the SNP. She has said this week, and you will have seen her public statements on the matter, that the claims you're making are untrue, that you have no evidence to support them. In effect, she is denouncing you as a liar and a fantasist. Are you?
Well, what I would say is, given some of the things that have been said about me this week, I don't think you have to add more. There's plenty have been said. the key thing is the evidence. Now, I've already expressed my, and I assume your frustration that there's some evidence in this is not available to you. But there is no doubt, and it is absolutely certain, that the meeting on the 29th of March in the Scottish Parliament was pre-arranged for the express purpose of Nicola being briefed in the situation with regard to me and complaints, and the meeting on the 2nd of April arose from the meeting, or the final arrangements for it at least, arose from the meeting of the 29th of March. Otherwise, how on earth would I have known to turn up on the 2nd of April? There's no other way the invitation could be gathered. As to why the meeting of the 29th of March was for a substantial period of time, if we remember, effectively written out of history, and I know that some people say, well, what difference does 4 days make? The difference is, of course, if the meeting of the 29th of March is admitted, and indeed the subject matter is admitted, then it makes it very difficult to argue that the meeting of the 2nd of April was on party business as opposed to government business. And all I would say is that that meeting was, in Nicola's terms, forgotten about, but she says she was reminded of it in late January 2019 or early February 2019 in evidence to the committee. If that were the case, then under the Ministerial Code, the correct thing to do would have been to correct the record as timorously as possible, as opposed to waiting 18 months till Sky News broadcast it, as is what actually happened. I'm here under my oath, and I'm giving you the explanation under my oath. That is what happened from my belief. The one thing I would add, and be quite clear about this, that many of the attacks on Nicola in regard to this were about how she was trying to intervene in my favour or whatever. I think there was nothing, and I've said so in my evidence, would have been improper with the intervention I was asking her to make. I mean, I'm well aware of what the Ministerial Code says. I was hoping that she would report to the Permanent Secretary what I'd said, as the Ministerial Code would indicate, because I could not believe that arbitration, or rather, I beg your pardon, I could not believe that mediation would not be properly part of the policy, and that might be a route forward. So I don't share the view that it would have been improper for Nicola to intervene. On the contrary, if a First Minister hears a substantive danger that their government might be drifting into illegality, or that something significant has been left out of a policy, then my view is that is a perfectly proper intervention to make.
Thank you. But can I press you on this point? Because it is of fundamental importance to the issue of whether the Ministerial Code was broken by the First Minister or not. Because she has one version of events, and you have a directly contrary version of events, and she has asked you to produce the evidence. Now, you've said to us you have no doubt that your version of events is correct, but where is the evidence? Who can corroborate your version of events?
Well, I'm not the only one who knew about the meeting of
who else did?
The 29th of March. It was known about certainly by Duncan Hamilton. It was known about by Kevin Pringle, I believe. And Mr Aberdeen didn't just tell me. I mean, obviously, Mr Hamilton went with us in the 2nd of April, so he knew about the meeting, the fact it had been arranged. So in terms of exact evidence, the people who turned up at the meeting knew. So that's corroboration. But in terms of the breach of Ministerial Code, I would have thought either explanation breaches the Ministerial Code, because either the meeting on the 29th of March wasn't forgotten about and Parliament was deliberately misled, or alternatively, it was forgotten about and Parliament wasn't informed when she was reminded of it. Now, my submission of the Ministerial Code says these are, to me, clear breaches of the Ministerial Code. What happens as a result is not for me. It's for this committee, it's for Mr James Hamilton, it's for others. All I can do is come here and tell you the truth, the whole truth and nothing but the truth, with the frustration, of course, that we all know there is evidence in terms of March 2018, which this committee is prohibited from hearing.
We can, of course, ask Mr Hamilton and Mr Pringle and Mr Aberdeen their version of events, and we may well pursue that. Can I just ask Convener a couple more questions?
Well, as I understood it, you had Mr Aberdeen's version of events in evidence.
Yes, we did. Perhaps I should move on, Convener. You allege in your evidence you've given us, the written evidence, that there is a conspiracy. You don't use the term conspiracy, but you say the evidence supports a deliberate, prolonged, malicious and concerted effort amongst a range of individuals within the Scottish Government and the SNP to damage my reputation, even to the extent of having me imprisoned. And you name, as part of that conspiracy, Peter Murrell, Ian McCann, Sue Riddick and Liz Lloyd. Why would these people conspire against you?
I believe the motivation for furnishing complaints to the police was initially to defeat the judicial review by having it postponed. I think it came to be believed that among some people that the loss of the judicial review, the loss of a court case would be cataclysmic, not just for Leslie Evans, not just for senior officials in the Scottish Government and special advisors, but would be cataclysmic for Nicola Sturgeon herself. And I think, unfortunately, people came to the belief that the police process would somehow assist in, firstly, not losing the judicial review, and thereafter making sure that the loss of the judicial review was swept away in the inevitable publicity of the criminal trial. And if I'd been convicted of any offence in the criminal trial, that would have been the case. Now, and you asked for evidence. Well, in the document I provided to you, in this committee, making the point about the investigative function, Barbara Allison was asked, would it be proper for the Scottish Government to be contacting people, where you describe it as contact or a fishing expedition or whatever, after the police investigation started. And Miss Allison quite rightly said, no, that would be totally improper. Once the police investigation starts, it's a matter for the police. But I've provided you with an email which shows that was happening. And the name at the bottom of that is Barbara Allison. And incidentally, I don't believe that Barbara Allison was a witting part of a malicious plan. I think, I know she was given that information by a special advisor to write unsolicited. A day later, Ms Riddick writes, and I'll false you provided with a letter from the SNP. The person concerned had never been an SNP member. We have a statement from that person, which was given to us for the purposes of my defence. You have the evidence put in by Anne Harvey. And the significance of the evidence of Anne Harvey is twofold. One, that the email she's provided is contemporary. This is a senior official in the SNP Whip's office at Westminster, a lawyer, an officer of the court, who's asked for names, refuses to provide them, because she says, in terms of her professional responsibilities, she's not going to participate in a witch hunt. This is not something she's describing now after the event. This is something she was describing in late August 2018. These things were going on after the police investigation started. In terms of what's in the public domain, then can I point out that in the criminal trial, my counsel read out a message from a complainant refusing to go to a meeting with a senior official because she was beginning to feel pressurised rather than supported. In Sky Television, I've seen an account of a text message of the importance of getting another complainant back in the game from Miss Riddick. I've seen reported and in the public domain a text message which says that if the police can't find the evidence, if it felt like telling them what they need, and I'll get it for them. Of course, again at the trial, a text message was read out saying, I have a plan by which we can remain anonymous. Now, these are things, material, which are in the public domain. There are also material which, as I mentioned earlier, that were said before they came into the public domain did not exist, or their bona fides were questions, which of course was the first response to the pressurising the police and all fronts, issue for more fronts to fight on. That was the first response. It can't possibly be true, but they are true. The messages are real. These messages are in the public domain. The evidence from Anne Harvey and of the emails which I provided you with is before this committee. There is much more evidence that I would dearly love to provide to this committee if I wasn't under an injunction in terms of Section 162 that I'm not allowed to provide to a parliamentary committee evidence which was disclosed to me as part of the criminal proceedings. And like in all things, I've abided by the legal advice and I must follow that stricture. Even though, as I noted earlier, as First Minister who introduced Section 162, it was never designed for that purpose. It was designed to stop witness statements being used by drug dealers or whatever to pressurise witnesses. It was designed to stop witness statements being discovered in skips across Scotland. It was part of Lord Coulsfield's report of 2007 about the handling of information. It was never, ever designed to prevent information coming to a committee of this Parliament. And its use in that fashion by the Crown Office is beyond belief and totally and utterly disgraceful.
Just two more brief questions, Convener,
Yes,
if I may.
could I ask, please, Mr Salmon, to not go back to the criminal trial, but to stick to the remit of this committee, please? I understand that you think a lot of these things are peripheral, and I let you answer that question in full, because it's obviously important to you and important to members of this committee. But if we could just bear in mind from now on that we should be sticking within remit. Thank you.
Of course, I'll follow your advice, Convener. I'll follow your orders in terms of the position. Just to say, I mean, the evidence coming to this committee is relevant to this committee. The origins of the evidence are maybe out of scope, but the evidence, if it's relevant to this committee, is relevant. That's the point I'm making, and not.
Yes, Mr Salmon.
I mean, clearly and obviously you're correct. The committee's remit is not to rerun the criminal trial or to question the verdict of a jury.
Mr Salmon, I understand what you're saying, but we also have a policy of taking evidence, which is that the evidence comes in and we decide our publication policy. And that's what we do. So to talk beyond some of the evidence that we have published can become problematic in terms of our remit. As I said, I was content to let you finish answering that question because it was important to you to get that on record, and it's important to committee members to hear that. I just want to give a warning as to where we go from here.
And then I'll follow your guidance.
Thank you.
Thank you, Convener. Just to go back to my previous question, Mr Salmon, you name in your evidence 4 senior figures within the SNP, including the Chief Executive, who of course is married to the First Minister, and the First Minister's Chief of Staff. Do you believe the First Minister herself played any role in this?
Well, as I've said, Mr Fraser, everything I've said in the evidence that I've submitted to you can be backed up by documentary evidence. So every statement I make, and therefore, since I don't have documentary evidence which suggests that the First Minister has text messages or any other piece of information which involve the First Minister, then I haven't made that accusation. That is because I decided, quite properly, I think, only to make statements that could be backed up by documentary evidence. Can I also say that you mentioned earlier, you said, look, you've never mentioned the word conspiracy. That's for the same reason. It's the easiest thing in the world, and it's been done over the last few days, to say something is a conspiracy theory. The reason I've described this in the way I've done as a malicious scheme or plan or campaign over a prolonged period of time involving the people I've named is precisely because there is documentary evidence which substantiates that. And that's not a theory, it's not a point that can't be established. it is a point that can be established from the documentary evidence. So it's more than just terminology and people's ability to dismiss it. What it is saying what can be verified by documentary evidence. And the only question is how much documentary evidence this committee is allowed to see.
Thank you. Convener, my final question. Mr Salmon, you conclude your written evidence to us of the 17th of February by saying this. The real cost to the Scottish people runs into many millions of pounds, and yet no one in this entire process has uttered the simple words which are necessary on occasions to renew and refresh democratic institutions. I resign. Who should resign?
I think the people responsible for the disaster of the judicial review, I think in terms of Scottish Government, the Crown Office, and in terms of the overall approach, the people who are responsible should resign. The people I've named, as I have the evidence for their behaviour, they should be all considering their positions. Well, as I said in January, I mean, the Permanent Secretary, and I think I say it in my evidence, I mean, to my knowledge, Cabinet Ministers thought she should have resigned on January the 8th, 2019. I can't think many people wouldn't have thought that would have been an appropriate thing to do. Yes, she should have considered her position then, and no doubt she can wait the findings of this inquiry. But and if you're asking my opinion, yes, she should.
Lord Advocate.
I think the Lord Advocate should be considering his position for this and a range of other issues. The issue here is that it's an argument as to whether there's an institutional failure. Many people whose opinions might be close to yours, much closer to yours than mine, have been using this argument to say, the institutions, there's something wrong with them. Scotland is almost a failed state. That's not a view I take. I take the view that the institutions fundamentally are sound, but there has to be some form of political responsibility. You know, institutions have to be refreshed from time to time, and one of the things in public policy is when an issue like this arises, of the extent it arises, that people have to take the consequences. If they don't take the consequences, then the institution itself comes under question. The Scottish Government, in terms of the Administration and Civil Service, needs new leadership. So does the Crown Office. And in terms of the people I name, because I have the documentary evidence to establish what they were involved in, then they should be facing the consequences as well. But in terms of the institutions of Scotland, I think they're absolutely sound, and what it needs is public accountability and facing up to the extent of what has been demonstrated by this extraordinary affair.
If the First Minister has broken the ministerial code, should she resign?
Not for me. I believe the First Minister has broken the ministerial code, but that is a finding that can be discussed, at least by this committee, by Mr James Hamilton. It's not the case that every minister who breaks the ministerial code resigns. I mean, your own party would have an example of that relatively recently. It depends on what is found and the degree by which the ministerial code has been broken. I've got no doubt that Nicola has broken the ministerial code, but it's not for me to suggest what the consequences should be. It's for the people who are judging that, including this committee.
Okay, thank you, Commissioner.
Okay, thank you. Stuart McMillan.
Thank you. Mr Salmond, earlier on you spoke about the discussion that you had with Nicola Sturgeon at her home. And you indicated also that at some point afterwards that Nicola Sturgeon seemed to have kind of changed her opinion. Can you remember what was actually said at the meeting in terms of what you said to Nicola Sturgeon and what she said to you, to give you an indication that she was looking to assist or help?
No doubt the people at the meeting that Mr Aberdeen and Mr Hamilton, and they were there, and certainly Mr Hamilton was there when Nicola said that, and she said it in the private meeting to me as well, that she was anxious to assist. But of course, it's not. I don't have to remember it. It's in the WhatsApp messages that you have as a committee. That when I'm surprised by Nicola's response, and I say to her, look, that's not mine. I was being, because obviously I was looking for Nicola's friendship and assistance quite properly. When I say in the message you have before you of the 3rd of June 2018, my recollection of our Monday the 2nd of April meeting was rather different. You wanted to assist, but then decide against the intervention to help resolve the position amicably. Now is different, and that's when we go on to the judicial review. I believed it was a substantial change, as this indicates, in Nicola's position, and I was extremely disappointed. However, I thought there were other possibilities. And obviously we've discussed arbitration, and that came later in the discussion. So that was the purpose. But I was extremely disappointed because I thought that at that stage that mediation was an entirely proper thing to suggest, and I thought that Nicola could entirely properly support it for the reasons I've already given. And I simply don't have any time for the idea that it's impossible for First Ministers in terms of the Ministerial Code to make proper interventions. I mean, the first thing you should do if you get contacted on an issue of government policy is you should contact the civil service, tell them, in this case the Permanent Secretary, and my assumption is not only was I suggesting Nicola should do it, but that was the right thing for Nicola to do. She obviously took a different opinion, but she changed her mind.
Well, thank you for that, but can you remember exactly what was said at the meeting that gave you the indication that Nicola Sturgeon would have intervened as you had requested?
She wanted to assist. She said, I want to assist. There was a discussion about how she could do it. So the discussion wasn't whether she wanted to help, it was about what were the circumstances which would enable her to do it. And she wanted, as the discussion with the Permanent Secretary, to come to her or to find an occasion by which they could introduce it. I found this rather puzzling because it's not the relationship that I had with my Permanent Secretaries. But it wasn't a discussion about whether she was going to help in the 2nd of April. It was how she could best do it. That was the discussion. That's why I was so disappointed in the message I've just read out to you.
Okay, thank you. I've got one more question. It's in a different area, Convener.
No, just say.
Okay, thank you. Certainly, earlier on today, and also in your evidence, discussed about a number of employees and associates, and certainly in your evidence you seem to consider instances of people reaching out to employees and associates to offer support on the subject of sexual harassment as evidence of a phishing exercise. Do you think that it's actually perfectly reasonable for political employers, whether it's the SNP or the Labour Party or Lib Dems or Conservatives or Greens, do you not think it's actually imperative upon the political parties to actually reach out to their current staff members and former staff members? Certainly, certainly they would have that duty of care to them, and bearing in mind also kind of what was going on at the time with society. And do you not think that it was the right thing for certainly for the SNP to do, to engage with their staff?
Yes, I do, but that is not what I'm suggesting, Mr McMillan. I made the point that the police investigation started, if I remember right, on the 25th of August and was publicly announced. At the point a police investigation starts, they are the investigatory authority. I'm not talking about reaching out to people. And Peter Murrow, in his evidence, gave not the impression, I think he gave it to the committee, the email that went out from Nicola Sturgeon to all party members towards late August 2018. What he didn't give this committee was the email that went out from Susan Ruddock, not to all party members, but to selected members of staff and former members of staff. I could produce for this committee many members of staff who didn't receive this email. It didn't go to people who were known to be close to me or worked in my office. Now, you'd think if you had a duty of care, these are exactly the people you'd be sending an email to. But the primary point is this. This is taking place after the police investigation has started. And secondly, the response from Anne Harvey, as I say, a solicitor, officer of the court, to it, she had no misunderstanding or no appreciation that it was anything other than what she described, her words, as a witch hunt. And she described it at that time. There's nothing more important than the understanding that once the police are doing their job, they should be left to get on with it. They shouldn't be pressurised. They don't need anybody else doing the investigation. They are the competent lawful authority for doing it. Unfortunately, as these emails substantiate, there were people who didn't believe that it should be left like that. Now, you don't need my word for this, because before this committee, when asked, Barbara Allison was asked, would it be proper for the Scottish Government to be doing that after the police investigation started? And she said no. The problem is that they were. And the email you have before you demonstrates that they were. I also know that the former member of staff that she's talking about in that email happened to be a special advisor. I also know that special advisor was given the details, which in itself is a question, of the person concerned by a significant person in the Scottish National Party. That should not be happening, Mr McMillan. That is totally out of order. But can I tell you that the information I would like to bring to this committee goes way, way beyond that.
Okay, thank you. Thank you, Convener.
Right, can we go now, please, to Jackie Bailey?
Thank you very much, Convener. Mr Salmon, have you covered in your response to Murdo Fraser all the text messages that are in the public domain?
Yes, the reason that I covered these ones is precisely because they're in the public domain. That's because, as you know, Section 162 has further clauses which exclude things that are in the public domain. For example, this committee was able to consider the messages that were mentioned earlier precisely because they ended up in the public domain, and once they were in the public domain, could be properly, and the same provision applies. I'm restricted under legal advice and under pain of prosecution by the Crown Office not to tell you messages which are not in the public domain. But equally I can, and I pointed out that never mind the ones that are not in the public domain, there is a substantial body of evidence that we can speak about.
Okay, thank you very much. Can I just check that I've got my timeline right? So you were told by the Permanent Secretary on the 7th of March 2018 that there were complaints against you. You were told by Jeff Aberdeen, following a meeting he had, about complaints against you, and that was on the 9th of March you were told by him. Was that also the date you were told the name of one of the complainers? And then the meeting between the First Minister and Jeff Aberdeen on the 29th of March, you were saying was pre-arranged. Have I got all of that right?
Yeah, the one thing I'd say, the telephone conversation on the 9th of March with my former Chief of Staff, I was in a car with other people, and I did no talking whatsoever. I can't be absolutely sure, because I spoke to him again and about 4 days later on the 13th of March, whether it was on the 9th of March or the 13th of March that he told me the name of one of the complainants, because he'd been told by a government official. But what I can be absolutely certain of is he told me, whether it was in the 9th or the 13th, that Jeff Aberdeen told me the name because he'd been given it by the government official.
Okay. So clearly before the 2nd of April, when you were going to visit the First Minister in her home, you knew that there were complaints against you, and you knew the name of one of the complainants. You've already established with other colleagues that you weren't resigning from the SNP. So when Peter Murrell said it was a government matter and Nicola Sturgeon said it was a party matter, it would appear that Peter Murrell was right on this occasion.
It was a government matter. It was about the complaints against me. There's no doubt about that.
So can I ask you again, as a former First Minister, if you were approached by a political colleague as you approached Nicola Sturgeon on the 2nd of April, would you have notified the civil service?
Well, in the circumstances and that were there, I would have gone to the Permanent Secretary.
Okay.
And that's obviously what I was urging or asking Nicola to do or seriously consider. I was obviously disappointed that she couldn't see that was the way forward. And I wouldn't have asked her to do it if I didn't believe it was totally legitimate. You can see from the WhatsApp messages, I tried to argue that this was the legitimate thing to do. I wasn't asking her to out with the Ministerial Code, because I don't see there's anything in the Ministerial Code that prohibits Nicola from doing what I asked her to do. What I think there is in the Ministerial Code a great deal of information that if you are told seriously that your government may be drifting into illegality, you're meant to do something about it, and that is specific.
Okay, whether let me drive home my point. Whether she intended to help you or not, by the conclusion of the meeting, there was no doubt what you were there for and what you were discussing. So at that point, is there a requirement by the Ministerial Code that she should report that to the Permanent Secretary? Because it potentially was a conflict of interest on her part.
Well, yes, she certainly should report it to the civil service. In this case, I would say it's the Permanent Secretary because of the nature, yes.
Okay, so failure to report it would be a breach of the Ministerial Code.
I think that's in my evidence. That it's not in my view, it's not the it wouldn't have been the intervention that's the breach, because I think the intervention is perfectly proper if it had taken place. It's the failure to report that is a breach. Yeah. It's the non-intervention, if you like.
So the First Minister offered to intervene, according to you. Is it
said that when it was the appropriate time, when as I say, the conversation was not about if she'd intervene, but when. And Nicola's anxiety was that she wanted to find a situation where the Permanent Secretary came to her or a suitable moment to do it. But there was no doubt that I believe she was going to assist in that direction, in what I believe was a perfectly proper purpose of securing mediation.
okay? Can I ask you, was that just a conversation between you and her, or can anybody else substantiate that?
I am absolutely certain that Duncan Hamilton was present when we were discussing that. I can't be absolutely certain about anybody else, but I know that Duncan was there, because as my counsel, obviously, when we were talking after the meeting and assessing what was happening, we both were of the opinion that the intervention was going to be made, and we thought the meeting had gone extremely well. So therefore, I absolutely know that was then and is now presumably his recollection.
Okay. Can I ask you then, there was contact by telephone, I think on the 23rd of April. There were messages from the First Minister to you on the 1st of June. You messaged her on the 3rd of June. And 7th of June, you had a meeting in Aberdeen. Why did the First Minister wait until June before reporting this contact to the Civil Service?
That's a question you should direct to the First Minister.
Okay. As a former First Minister, when would you have reported the contact to the Civil Service?
Well, obviously, I'm not a impartial observer of this. If somebody had come to me, let's put it this way, if Nicola had come to me in similar circumstances, hopefully we wouldn't have been in the problem for a policy which was misdirected for some reason. Because hopefully we wouldn't have had a misdirected policy. But if we had and these things happened, they'd come to me, then I would have intervened in that direction, because I could see from the Ministerial Code it was perfectly proper to do so. My view is that there are times, as First Minister, or times in life that you cannot assist your associates because it's diametrically opposed to something which you have to abide by, because you've pledged allegiance to, and all ministers have to pledge allegiance to the Ministerial Code. But if there is, within that code, the proper reason for doing something, then you would do it. Certainly I would, and I suspect you would as well.
It's a long time since I've been a minister. I can remember it, though. Let me ask you one last question. Given your knowledge of the Ministerial Code, is it not the case, if you are misleading Parliament and you don't take the opportunity to correct it, it is automatic that it is a resignation matter?
Yeah, the two things are a bit different. There have been there are very, very few occasions of somebody established as misleading Parliament who hasn't resigned. Other breaches of the Ministerial Code, which would probably include the time of a correction, would be a breach, but it's not as open and shut as whether that's a resignation matter. I mean, these things are movable gold, but the generally applied position is if you have knowingly misled Parliament then you would resign. It's not as clear as if it's inadvertent, but certainly not reporting an inadvertent misleading would be serious. Whether that's a resignation matter, as I said earlier to Mr Fraser, is for others to judge.
Much convened.
Thank you. And now move on to Alistair Allen, please.
Thank you very much, Convener. As you know, Mr Salmon, we've been looking at mountains of evidence about this over the last few months. I think there's probably, although I don't want to try and speak for the whole committee, quite a lot of agreement about the shambolic nature of some of the elements or some of the ways in which parts of this whole story were handled. However, your written statement to the committee and some of what you've said today goes a great deal further than that and names a large number of people, including the Crown Office. I just want to ask, I appreciate you've set out some of the reasons why you feel frustrated about evidence being publishable and so forth, but I just wonder if you also appreciate our predicament, which is that in our report that we produce, we have to rely on evidence. And do you understand why evidence is required for some of the statements that you've made?
Well, any statement I've made is evidenced by evidence you have. I've brought forward the evidence which demonstrates that after the police investigation had started, others in government and the SNP were taking on, interfering, if you like, with that investigatory function. The email from Miss Allison is quite specific about me. So that is pretty strong evidence. I brought forward evidence from Anne Harvey, which is strengthened by the fact it's contemporary, and an affidavit which has been much redacted, but nonetheless you have, which supports that. So both in the contemporary sense from August 2018 and her reaction now, then you can see that that is evidence that has been brought forward. There are, let's see, 6 text messages which we have referred to, which are in the public domain, some of which you have in evidence before this committee. You have the ones that were read out earlier. You have the lost the battle, win the war text message. I made the point that both of these were denied until, of course, they came into the public domain and before this committee. And I've read you out today another 4 messages which are in the public domain elsewhere, including 2 which were at the criminal trial. Now, that is a substantial body of evidence. In terms of the Section 162 and what it's being applied, I'm afraid I don't think this committee is helpless, and I don't think it should be helpless. That is a misapplication of a section in an Act. I was First Minister, Mr McCaskill was Justice Secretary, Frank Mulholland was Lord Advocate. Between the 3 of us, we must know as to what the purpose of that section was. I've pointed out exactly what the purpose it was. It was never, ever to prevent a parliamentary inquiry receiving evidence. And I can, as I pointed out earlier, I think in questioning to Andy Whitman, that this is not just about text messages in the SNP. This is also about government documents that this committee should have seen. You should have seen. I'm not talking just about the external legal advice. I'm talking about documentation that you don't have for about a 4-month period between late August 2018 and early January 2019. All the documentation you've got is virtually silent on that entire period. So, you know, I don't think a parliamentary committee in these terms is helpless to say to the people who are not giving them the evidence, we want to have it. And of course, I think it was offered in one of, I think the evidence session from the investigating officer. She was asked that question and said she'd have a look and see if she could find it. Well, unless you've got it and not published it, I certainly don't see it. So I don't think you're helpless in this matter.
Well, when you mention Section 162, you have said that the Crown, specifically the Lord Advocate, has more discretion than has been used on some of these matters, which would allow to disclose to this committee material which you obtained as part of the criminal trial. Now, you've mentioned I think you're mentioning the 2010 Criminal Justice and Licensing Act, which, as you say, was introduced while you were First Minister, and you have material in your written evidence in relation to that. I think my question is really that if that discretion exists, is it not the case that during the introduction of that bill, the government seemed to rule out introducing a power that would give them such discretion? So when the Act was in draft form, it included a Section 100, a provision that explicitly allowed exactly what you seem to be suggesting, the disclosure of evidence to a third party. But on the 4th of May 2010, at stage 2 of the bill, the government removed that section from the bill. Now, without getting drawn too far back into history about all of that, I appreciate. Do you understand why some people do not feel that the Crown has the kind of discretion that you are setting out and suggesting that it does?
Well, can I compliment you on your research, Mr Allen? What I can tell you for an absolute definite, that legislation was constructed in the back of Lord Coulsfield's report of 2007. If you read Lord Coulsfield's report, you'll see exactly what the concern was. The concern was that witness statements were not being kept properly by solicitors. Presumably in these years, their filing cabinets were full up and they were appearing in skips all over the country. And there was also a concern that witness statements might be used for pernicious purposes by people to get revenge on people who'd given witness statements. This committee are not a third party. You are a parliamentary committee. You're a committee of the Scottish Parliament. You're not Joe Soap or Joe Bloggs. You're a committee which is there to find out and investigate and to do it in terms of the duty you have to the people of Scotland. You're not people who are not entitled to receive that information. And you say the Crown hasn't exercised discretion. That has not been the attitude of the Crown. I've got here the letters. 3 of them have been written to me and my lawyers. The first of which provoked by, we offered at the, I think it was the Assistant to Clerks, that we would, as opposed to giving you the evidence, we would set out which evidence at that stage you didn't have before you as a committee. And what we got from the Crown Office was a letter saying if we did that, they'd prosecute, effectively. Then we got a second letter, just in case we hadn't appreciated the content of the first letter. And then finally, we got a letter which said, even if we responded to a request of the clerk, then not only would they consider us for prosecution, but they said anybody using that information would be prosecuted. The only way to read that is this committee. Now, if you think that would happen in terms of reality, I suspect it wouldn't. But the degree of effort of the Crown Office to prevent this committee from seeing evidence that it requested, not just SNP text messages, goes beyond any imagination. And then, of course, when they did provide you with messages, they provided you with messages that no committee could ever have published because they were outside your remit. Nothing I've ever asked of evidence to produce would involve divulging the identity of complainants. The people for which the evidence could come from the SNP were not complainants, and the government documents that are concerned here are matters that this committee should have had by right when you were promised the full cooperation of the government when you established your proceedings.
Thank you, Convener.
Thank you. Andy Whiteman.
Thanks very much, Convener. Thank you for your patience, Mr Salmond. At times moving on. I don't want to turn this inquiry into debate about the meaning of legislation, whether the Arbitration Act or the Criminal Justice and Licensing Scotland Act 2010, but I would just observe I have section 162 in front of me, and subsection 2 says that the accused must not use or disclose the information or anything recorded in other than in accordance with subsection 3. And there's nothing in subsection 3 that allows you to disclose that information to a committee of the Scottish Parliament. So we can have a debate about the actual intention of that, but the actual act as passed seems to be very clear.
I was only saying, Mr Whiteman, that you know, it's very unusual to have the person responsible for the act sitting in front of you, and therefore it's not just an observation. And I'm sure that if he wanted to check the matter with the then Justice Secretary and the then Lord Advocate, they would be able to inform the committee of what the intention was.
No, I don't doubt that that may well have been in the intention. All I'm doubting is that actual intention never made its way into an enactment. But I also don't deny the fact that the information you're talking about, Scottish Government documents, should be with this committee. I don't doubt that at all. They should be. I have no view on that. Can I just go back to your mention of the email, the affidavit of Anne Harvey that you mentioned? You have a view on the purpose of the email from Sue Ruddock, etc. And I don't want to rehearse that. You've made it clear what you believe the purpose is. But I just want to clarify that as a matter of principle, if I, for example, were a victim of an alleged crime, and the police were investigating what I'd reported, do you agree that it would be legitimate as a matter of principle, setting aside the exact circumstances of this case, it would be perfectly legitimate for me to contact people who I thought were potentially the victims of the same crime, because a police investigation was underway, and if they had any complaints, this would be a good opportunity for them to bring it to the attention of the police and make a complaint? That would be, in principle, a perfectly legitimate thing to do.
Yes, it would.
Okay, thanks. Can I move on to your...
In that case, you wouldn't be the person who was responsible within the organisation in terms of doing it. But there's obviously a crossover between somebody pursuing complaints and somebody who's responsible for providing that information in the organisation.
No, I don't
understand.
I understand the specifics. You have a different interpretation of, but that was just an in-principle question. In your fourth submission to the committee, on page 2, you talk about the Parliamentary Committee has already heard evidence of activities by civil servants, special advisers, ministers and SNP officials, which taken individually could be put down to incompetence, albeit on an epic scale. However, taken together and over such a prolonged period, it becomes impossible to explain such conduct as inadvertent coincidence. The inescapable conclusion, you say, is a malicious and concerted attempt to damage my reputation and remove me from public life in Scotland. You've said that everything you say in evidence to us, in written evidence, that you can back up. Can I put it to you that there's nothing that we've heard that proves that this, in fact, is the inescapable conclusion, nevertheless, that such a conclusion may be consistent with these facts, but there's nothing actually that proves it. Would you agree?
No, I think the reason I set it out like that is, I mean, I can go through the various things if you like, but I mean, you know, I suppose if I was to highlight 6 things to you that you know, one would be the timing of the policy on former ministers, and the fact that, as has been said earlier, that 2 days before this policy started to be constructed, there was the query about Edinburgh Airport. I've already said that query came to nothing, and understandably so, but I don't think that was a reaction of the Permanent Secretary at the time. That was on, I think, the 6th of November, and the 8th and 9th of November, of course, is the first iterations of any sort of policy from 2 different civil servants, one who said he was starting with a blank sheet of paper, but there was another civil servant who also presumably had a blank sheet of paper. I'd have thought the open record meeting of the 29th or 30th November between the Permanent Secretary and the First Minister is significant. Basically because up until then, every iteration of the policy placed the First Minister in the policy at an early stage. But by the 5th of December, the policy had changed dramatically, so that the Permanent Secretary became the key decision maker. You know, this committee knows, that the Permanent Secretary had knowledge of the emerging complaints, certainly by the 22nd of November, and actually before then. Therefore, the very least you could say is that the Permanent Secretary put herself at the centre of a policy as the decision maker with the knowledge that complaints were coming forward. That is the minimum conclusion you could draw from that. And it was a radical departure in terms of Scottish Government policy. I think, thirdly, the Crown Agent, as you, I think actually it was you in questioning the Permanent Secretary, you pointed out that what the policy says under certain circumstances the Scottish Government would refer to the police. It doesn't say refer to the Crown Agent. I think that is significant, and it's highly significant that the Crown Agent's attempt to give the Chief Constable and the lead officer a copy of the Permanent Secretary's report was declined by them because they said it might influence their investigation. And the decision, despite the information that was offered by the police, that they would be opposed to matters becoming public in case it contaminated their investigation, that despite that, it was the intention to release a press statement on the 23rd of August, 2 days later, which was stopped, of course, by the threat of interdict. The fourth point I would put, which is well known to this committee, is the question of the external legal advice, probably, as we know, on the 31st of October, and the extraordinary lengths that have been gone to prevent that advice being shared by this committee and the Parliament. We know that what was in the content of that advice, even reading it, was strong. We don't know the full extent of it, but certainly I think we conclude that the external legal advisers were telling the government at that stage that the prospects were not looking good, to say the least, for the judicial review. Therefore, what possible reason could there be for extending that action, which would be much, much more difficult when it came to court than it would be in an earlier concession, never mind the hundreds of thousands of pounds that are being wasted, unless there was a hope of the review perhaps being assisted, never coming to court, which is why it comes to be a major point in terms of the non-provision of assisting information. The fifth point I'd have is also, which we've been discussing, is the question of the integrity of the investigative function. And my belief is that once the police start an investigation, then it's not for other agencies to be conducting parallel investigations. That is quite wrong. It's one matter to be assisting the police with their inquiries, which every responsible citizen should do. But you shouldn't be trying to assist them with inquiries to the extent of producing the evidence you're frustrated that the police can't find, or creating the evidence, or suborning witnesses, or pressurising witnesses, or pressurising the police. All information which this committee has. And finally, although the full extent of neither the government information nor the text messages known to the committee, we've already read out, and between Miss Mitchell and myself, half a dozen such messages which are in the public domain and which can be considered by this committee, because the one exemption there is in section 162, if you look further down, is that it exempts information which is in the public domain. Now, these 6 instances, I think, give you pretty substantial justification for what you've just read out to me, looking at them individually, but all 6, and perhaps another dozen that I could mention as well, but just taking these as the main themes, that, I think, is not an unreasonable conclusion. Obviously, my conclusion is informed by other material that I've seen.
Okay. Thanks very much for that. Again, on your fourth submission, I've just got 5 points should be dealt with a little bit more briefly. On page 11 of your fourth submission, you say, from a very early stage in the digital review, the government realised that they were at risk of losing. By October, they were told by external counsel that on the balance of probability, they would likely lose. Now, again, you've said that everything you write here can be backed up by evidence. What's your evidence of that, given that we haven't seen that advice? How do you make that conclusion?
Well, how do you prove advice hasn't been produced? I've not.
You say quite clearly, by October, they were told.
Yeah.
How do you know that?
Right. I'm saying that that is the case, and I've got every reason to believe that's the case, and I believe that's the reason you haven't been shown the external counsel legal advice. No, but I wouldn't be here saying it's the case unless it absolutely was the case.
Because you're speaking under oath.
I'm speaking under oath, yes.
Okay, thanks.
And that's the whole point of speaking under oath, and you won't be getting a correcting letter several days hence to correct that statement. I have every absolute reason to believe that legal advice on the 31st of October, as I understand it, but certainly about then, it indicated that on the balance of probability, the government were going to lose the judicial review.
Okay, and on page 15, can I ask you if it is on the same basis that you've just answered that question, that where you write, this information on likely defeat in the GR was communicated to key decision makers, the Permanent Secretary, First Minister, the Lord Advocate, the Chief of Staff, in meetings with external counsel through October and November 2018. So on the same basis that you've just told me, that you believe that to be true.
Well, and also the basis that you've seen from the Freedom of Information request,
Sure.
the list of the 17 meetings, and you've seen the sequence of meetings, as Paul Coquette indicated, it was read out earlier on, of that nobody was under any illusions about the significance of the information that had come forward. He didn't explain why it hadn't come forward, but nonetheless, that nobody was under any illusions. And the sequence of meetings with external counsel is set out on the FOI. And of course, the participants at these meetings, and you'll have seen that on free meetings running, the First Minister's Chief of Staff was there, the Permanent Secretary was there, and then the Permanent Secretary and the First Minister were there in early November 2018. So you have that evidence plus the evidence from the FOI and the sequence of meetings. What you don't have, of course, is anything from either these meetings out with the external legal advice itself. You don't have anything from these meetings or any of the daily meetings spoken about by Paul Coquette or any of the 3 times a week meetings spoken about by Judith McKinnon. I really think you should go and get them.
Well, it's not for want of trying, Mr Salmond. We have, I think. Second last question. In the ICO, Information Commissioner Office report that you helpfully provided to us, with us, which is an investigation, actually I understand it's an appeal or review of a decision, but nevertheless it's a detailed analysis of the attempt to ascertain why information in the decision report got into the public domain. And at 4.3, the author of the ICO letter, forgive me, I don't recall who it is, but it doesn't matter. It says 4.3, I have also considered the statement of Detective Chief Superintendent, their names redacted, helpfully provided by Levy and McRae. The statement confirms that at a meeting on the 21st August 2018, the police were offered a copy of the internal misconduct investigation report but refused to take it. Furthermore, at that meeting, DCS, redacted, voiced concerns about the SG, Scottish Government, making a public statement about the outcome of their investigations. So this statement that confirms these things, is this a statement that you have seen?
The proposed statement of 2 days later?
No, sorry, the statement of Detective Chief Superintendent, redacted.
Yes, it is, and it's a very interesting point you just raised, because, of course, that is an exemption to Section 162. The reason that we were able to give the ICO a copy of that statement is because the Crown Office permitted us to do so. So we've just had a discussion, and congratulations for pinpointing the point as to whether this parliamentary committee was entitled to see information under 162. That statement was provided for the ICO with the permission of the Crown Office, in itself an exemption to 162. So the idea that was put forward a few seconds ago that the Crown Office has no discretion in these matters, well, clearly they found discretion as far as the ICO is concerned. And let me say, no complaints about that. That was exactly the right thing to do, to provide that information to assist the ICO in its investigations. My argument would be it would also be the right thing to do to assist a parliamentary committee of the Scottish Parliament.
Okay, and just on that, the reason for asking that really was due to my own ignorance as to whether this committee has that statement. To your knowledge, has that been disclosed to this committee?
No, it was disclosed to the ICOs.
Do you have a copy of it? Levy and McRae?
Well, Levy and McRae have a...
Would you be able, were this committee to ask you or to ask Levy and McRae, would they be able to provide it to this committee?
Well, not according to the Crown Office.
Okay, thanks.
We can certainly say we'll get the fourth letter telling us what we can and can't provide to a parliamentary committee. But the ICO investigators report, as you know, is very revealing, and I raised earlier the apparent discrepancy between what's said in this report about who had access to the information in terms of the Principal Private Secretary in the First Minister's office and what has been said and then corrected to this committee, which I think is worth pursuing.
Thanks. And just finally, this goes back to questions from Jackie Bailey about whether meetings on the 2nd of April, for example, and subsequent ones were by the First Minister were in a party capacity or government business. Can I put it to you that there's a third possibility here, that actually the subject matter of these meetings was complaints by civil servants against a former minister as part of the employment process you disagree with and all the rest of it, but nevertheless a complaints procedure in the civil service. It's not really party, and neither is it really government. Government is about the government's policy on housing and independence, etc. I'm just putting it to you, there's a third possibility that because this is a sort of internal employment matter, that it's not quite as stark as being party or government.
But you can put that to me, but that's not been the point I've been making about the meetings. What I've said about the meetings, there was never any doubt about what the subject matter was. It's up for others to explain, as they've been trying to do in front of this committee, as to whether they thought it was a party meeting or a government meeting. My point is there was never any dubiety about what the meeting was about. And in my view, there's no dubiety about the meeting on the 29th of March, which set up the meeting on the 2nd of April. And there's no dubiety that the 29th of March meeting somehow disappeared from the public record for an extended period until the fact of it was broadcast on Sky Television in July of last year. That's the questions I'm asking. You could put any construction on whether that's a meeting of one or a hybrid meeting or whatever it might be, but that's not been my point. It's maybe a point that others have developed, but not me.
Okay, thanks very much, Convener.
Thank you. We're almost at a close. I have Maureen Watt and then Margaret Mitchell, both with short contributions.
Thank you, Convener. Mr Salmond, you said in your written evidence that you support protecting the anonymity of complainers and that this is something that you've had upheld at every stage in this process, yet you've provided material directly to committee MSPs, some of which has then leaked into the public domain. There is a process that evidence goes to committee clerks so that it can be scrutinised by committee lawyers. It's not up to you or your lawyers, it's up to committee clerks and committee lawyers to decide what should go to MSPs and whether there's a risk within the material that there could be identification. So what was your motivation for not following the correct procedure, which was designed to protect the identities of complainers in a criminal trial?
Well, let me firstly refute absolutely that anything we have done or published or sent questions the identity or anonymity of complainants. And I've already given you the example in what's under your purview in terms of the remit of the committee, in terms of the civil case and the efforts we went to protect that anonymity in the Court of Session hearing where the government didn't bother to turn up. But in terms of the argument that we shouldn't send stuff to members of a parliamentary committee and somehow that's an irresponsible thing to do or not the right thing to do, I don't accept that. Every single member of this committee has their duties and responsibilities as a member of the Scottish Parliament. They're equal before this committee, and that is not sending to a parliamentary committee. What I thought was interesting that when Kenny McCaskill sent this committee information that he had received and sent it to the Crown Office, nothing happened with that information. It wasn't until it was published in the press that it became public, and therefore was. And to me, that was an extraordinary situation to develop. But I don't think, to answer your question, Ms. Watt, that it's a wrong or irresponsible thing to do. And I refute absolutely that anything we've submitted to anybody puts a question mark on the anonymity of complainants. And furthermore, the one paragraph that the Crown Office objected to, and I know you follow these things closely, was objected to not on the basis of being jigsaw identification in itself, but on the basis of information which had been previously published by this committee, which led to the Jigsaw identification. Now, these arguments can get very technical, but what is beyond argument is that 2 weeks ago, the Crown Office did not consider anything in the submission that was made to this committee to be in danger of breaching anything. And for some reason, earlier this week, on the very point of coming before the committee, there was a change in position. Anybody who has seen that evidence, and everybody who has seen that evidence, cannot understand why anything in that evidence gives rise to a risk of identification. These things are there correctly to protect the vulnerable, not to shield the mighty.
Can I just remind everybody again that that would be an issue for the Scottish Parliament corporate body rather than this committee? Margaret Mitchell.
Yeah, thank you. And these are my final questions, Mr Salmond. I don't know if you're aware, but the committee wrote to Police Scotland and we got information about the contact that had been made with them during the policy being developed and actually that 3-month period. And I think Police Scotland were told there were actually 6 meetings between first a contact on the 5th of December 2017 right up to the 3rd of August. And hypothetical questions were put, and the police quite clearly said, without knowing any details or hypothetical things, if criminality was suspected, individuals should be directed to support and advocacy. They also went on to say that this advice was reiterated on several occasions, and they conclude by saying really that if there was, if the Parliament was seeking to investigate themselves, they clearly were not qualified to do so. They didn't have the training. So that was before the final policy was concluded. So I suppose my question in going back to Stuart Macmillan is duty of care for these women who had come forward. We know they didn't want to go to the police. That's been substantiated in evidence. The sounding board and the duty of care absolutely is something you would want to put in place, but there was a real intensity of contact with the women, and I think it may have been your solicitors that said that may have been bordering on encouragement. And if that is the case, then the question is, for this plan, this malicious plan that you've outlined to discredit you and remove you from public life, if this was in place, the big question is, what was the motivation? Why? I think that's what everyone was asking. Just why did they do it? It just seems, so bizarre. But do you have a reason why you think that this process started and perhaps got a bit out of hand?
I think motivation changed over time, and just for clarity, I've never suggested for a second that the original complaints and complainers were anything to do with a motivation about me in politics or anything like that. I don't think that had anything to do with it at all. I think the complainants were incredibly poorly served, as you just outlined, by being forced into a criminal process against their direct wishes and against every assurance they'd been given over months that that wouldn't happen. I think it was Judith McKinnon who was asked, who asked you to sound them out? And she said that she thought it was Nicky Richards. It wasn't. It was the Permanent Secretary. And the consequences of that for the people concerned are huge. And it's totally wrong, completely and utterly wrong. I think the motivation for what I've said about the people I've named in the document is quite different. I think it came to be believed that the solution to a huge, looming, enormous difficulty and problem wasn't to just as I'm sure the Lord Advocate did, to consider assisting as a academic exercise or something that might have to come into play, but was actually a means of preventing something something unfortunate, more than unfortunate, something disastrous happening in terms of a defeat in the judicial review. The two things became to be combined. It became to be very important that the criminal case overtook the judicial review. And the messages I've seen indicate that as a prime motivation. So when I saw them, and I think it was the 23rd or maybe earlier of January last year, I found them extraordinary, probably the most shocking thing I'd ever seen in my life. Unless it was there in front of me, I couldn't have possibly believed it. So these people, if they ever came before a committee, should be asked about their motivations. But certainly what they revealed of themselves in these text messages would indicate that was the prime concern, was defeat in the judicial review, and the idea that somehow the criminal case would either overtake it, or alternatively, after the judicial review was lost, a criminal case against me, as of course, would blanket out all other publicity. It would be the most enormous story. And if I had been convicted on anything, then, as I've said earlier, we wouldn't have been having these hearings, and nothing would happen. So that would what I'd point to as motivation.
Right, so there wouldn't be any motivation. I think it's been thought about that you are a private citizen, that you might be contemplating a return to public life, and that by moving forward in this way, where there were so many times they were told the procedure was unlawful, they were told they weren't qualified to carry it out. If they had serious concerns, they should be directed to advocacy. They weren't trained, the government staff weren't trained, but they persisted, and they persisted with the judicial review to a point that just defies comprehension. So is that just absolute incompetence from people who are civil servants, well qualified, gilt-edged pensions, there to be impartial, in which case then that's deeply worrying? Or was there something else behind it? What was your relationship with the First Minister over years?
Firstly, I don't think the civil servants had a political motivation. I think motivations lay elsewhere. In the case of the Permanent Secretary, and I've seen previous evidence sessions where there are documents which suggest that her motivation was being seen to be in the vanguard of events, perhaps. But you have to ask the Permanent Secretary again exactly what her motivation was. In terms of not conceding the judicial review, then I think you're absolutely correct. I mean, if the judicial review had been conceded, for example, let's say October, then the bill to the public would have been very small in comparison with what it became. The huge bills came from having to go to the Commission in diligence, like 2 days before Christmas, as it sat, and people came into under oath. So any calculation that said, we are going to lose this, and what's the best thing to do? Well, it would be to settle it as quickly as you could and to minimise the damage, unless, of course, you believed for some reason or another that the judicial review might never come to court. It might be sisted into the ever after by the events in the criminal case. And my belief, strong belief, is that some people, unfortunately, weren't willing to let matters take their course, but wanted to give the criminal case a big shove forward. And the messages I read were one of the most distressing days of my life.
Okay, thank you.
Thank you. Can I just ask, Andy, was that you saying you wished to come in?
I just have one very short question.
Very short,
whenever,
please.
Now? Okay,
yes.
Thank you. Mr Salmond, do you have full confidence in the independent advisers on the Ministerial Code? And thus, can we rely on Mr Hamilton's findings as an authoritative statement of the facts and circumstances that he's been asked to look at when they're published? One,
I set up the system. Two, I appointed Mr Hamilton. I should say I never met him in my life, and I've only corresponded with him recently. I'm being interviewed by him, I think, on Monday or Tuesday, certainly in the very near future. I've got every reason to believe that he is a man of great integrity and experience, and is the sort of person. Well, I did appoint him to the panel. So the panel, of course, was introduced by me. Before that, there was no independent supervision of the ministerial code at all. And the panel, I think, has been a good innovation. The one thing I would say from recent experience, and you've seen the correspondence, is I think it's heavily unsatisfactory that the remit should be confined in any way. I mean, the remit should be determined by the independent panels, not set in strict terms. And I hope and believe that that problem has been overcome. But I've got every confidence that Mr Hamilton will discharge his duties in a proper way, and I think it's fundamentally a good system.
Thank you.
Right, I'm going to be very strict from now on. Jackie Bailey assures me with great intent that it's a tiny question. And can I have a tiny answer, please, Mr Salmond, if at all possible?
It is indeed a tiny question, Convener, I do promise. Mr Salmond has been very, very careful not to call for Nicola Sturgeon to resign. Does that mean you've forgiven her for her handling of this?
No, it means that the people I've named and the evidence that I put forward, I believe there's documentary evidence for the reasons that they should consider their positions. Whether you call it careful, whether you call it anything else, I don't think it's for me to judge what happens to someone who may have broken the ministerial code. If they have broken the ministerial code, if Mr Hamilton finds that, or this committee finds that, then I suppose the next question is, what is the breach? And then that will be determined. But I'm in the fortunate position as a former First Minister, that is no longer my responsibility. It's partially the responsibility of this committee, substantially the responsibility of Mr James Hamilton, and all of the responsibility of the Scottish Parliament.
Thank you very much, Convener.
Thank you. I have only one final little thing I wanted to ask, following up from what Margaret Mitchell was talking about. There has been a lot of discussion, obviously, and the word conspiracy has been used a lot, although I do note, Mr Salmond, that you said that that's not a word that you wanted to use. You talk about a malicious plan. From what I've picked up today, you've said repeatedly about your concern about this being after the police investigation has started. Can I just ask you to confirm to me, is that when you believe any plan started that was, what could we say, malicious towards you in its intent?
Yeah, I mean, yes, that is my view on the nature of what I've seen. And it became because of the circumstances that I've described, because of what was going to happen in the judicial review, and the hope that the police investigation would come to the rescue of that. I've got many parts of information. I would just say to you that almost happened. That very, very close to happening, not just in the time of the police interview, but the original date for the police interview came before the judicial review was due to hear, and it was only with the great work of my legal team that we were able to argue that shouldn't happen. So that almost came to pass now. We're in a position that we're in a position that the court and jury have decided, and therefore the matters before you are now very pertinent in the public interest again. But yes, the broad answer to your question is correct.
Thank you. Now, can I ask you, Mr Salmond, do you wish to make any final comments?
Only one, and that is that beyond the individual detail of this, there is a underlying issue which is about the powers of the Parliament, the powers of a parliamentary committee, the obstruction from the civil service, the obstruction, as I see it, from the Crown Office and the leadership of the Crown Office in terms of the parliamentary committee doing its job. I believe and hope and know that among this committee there would be a desire to be able to discharge that function if it was clearly able to do so. we've examined the issue of Clause 162 and whether there can be exemptions from it and whether that presents difficulties and the behaviour of the Crown Office with regard to it. I think there is a solution, and I'll offer it to the committee and leave it in your hands. Hitherto, you've been serving orders as a Parliament on people who've been unwilling to give you information. Can I suggest that you use your powers under the Scotland Act, and it's a matter for this committee, to serve that order on my solicitors, who are extremely willing to give you information? It's a matter for this committee, but if you do so, then I'm sure you'll get full cooperation under the law from my solicitors. Furthermore, if we're on a roll here, then the information of the letters from the Crown Office preventing me from furnishing you with that information hitherto is something you might also like to request under the same powers of the Scotland Act, and any other information which Mr Whiteman has come up with today, which would also be of assistance to the committee. For example, the official record of the Commission and Diligence, which I also think I have all these documents here as it happens. But if you decide as a committee you would like to go down that course, and clearly you've got to deliberate, then if you serve that order on my solicitors, you'll have the documentation on Monday morning in time for your sessions with the Lord Advocate, and I understand it, the Crown Agent, Mr David Harvey. It's a matter for you, Convener. And other than that, can I thank all committee members for their courtesy and forbearance, and particularly you, Convener, for allowing the break earlier on. That was much appreciated, and I wish you well in your deliberations.